Welcome to our comprehensive guide on inspection, inquiry, and investigation under the Companies Act 2013. In this video, we'll walk you through the essential provisions, powers, and procedures that govern how companies are inspected and investigated in India. We'll also discuss the roles of various authorities, including the registrar, inspectors, the central government, and the Serious Fraud Investigation Office. By the end, you'll understand not only the legal framework, but many companies, shareholders and management are separate entities. Shareholders elect directors to manage the company's affairs, granting them significant powers. However, this separation can sometimes lead to abuse of power by directors or officers, potentially harming stakeholders. To prevent such misuse, the central government is empowered to investigate company affairs, especially when there is suspicion of fraud, unlawful activity, or oppression of members. These checks and balances ensure transparency. Companies Act 2013 assigns specific powers to various authorities. The registrar can call for information, inspect books, and order inquiry. Inspectors have similar powers and can also investigate company ownership. The central government can authorize inspection, appoint inspectors, and establish the Serious Fraud Investigation Office (SFIO). Regional directors and tribunals also play a crucial role, such as appointing inspectors or freezing assets. Each authority. Section 200 of the Companies Act 2013 empowers the registrar to request information, explanation, or documents from a company. If, upon reviewing company documents or receiving information, the registrar deems further details necessary, they can issue a written notice requiring the company to respond within a specified time frame. This ensures that companies remain transparent and accountable, providing authorities with the information needed to assess compliance. A company receives a notice from the registrar. It is the duty of the company and its officer to provide the requested information or documents to the best of their knowledge. This obligation extends to past officers if the information pertains to their period of employment. Compliance is crucial, as failure to respond can lead to penalty. This requirement ensures that all relevant facts are accessible for a fair and thorough inquiry. If a company fails to provide adequate information, or if the registrar finds the response unsatisfactory, an additional written notice may be issued. This notice can require the company to produce further books, paper, or explanation at a specified place and time. Before issuing such a notice, the registrar must record the reasons in writing. This step-by-step escalation ensures that companies are given multiple opportunities to comply before stricter measures are taken. Registrar may initiate an inquiry if there is evidence or representation that a company's business is being conducted fraudulently, unlawfully, or not in compliance with the Act. Before starting the inquiry, the company must be informed of the allegations in writing and given a reasonable opportunity to be heard. This process ensures fairness and allows the company to present its side before any further action is taken. Central government can direct inspections of a company's books and papers by appointing an inspector if circumstances warrant such action. Additionally, it can authorize statutory authorities to inspect the accounts of a company or a class of company. These provisions ensure that higher authorities can intervene when necessary to safeguard the interests of stakeholders and maintain corporate integrity. If a company or its officers fail to furnish the required information or documents, they can be penalized with fines. The penalty may extend up to 1 lakh rupees, with additional fines for continuing failures. These penalties serve as a deterrent, encouraging companies to comply promptly with regulatory requirements and maintain transparency in their operation. The Axis Ispat P. Limited v. Union of India case, the Delhi High Court clarified that the registrar of companies must provide a company with an opportunity to be heard before issuing a show cause notice. This ensures that companies are treated fairly and that their responses are considered before any punitive action is taken. The case highlights the importance of due process in regulatory proceedings. High Court of Andhra Pradesh and Telangana ruled that the registrar's jurisdiction under Section 206(4) is suo motu, meaning the registrar can act on their own initiative if there is evidence of fraudulent or unlawful business conduct. This empowers the registrar to proactively safeguard the interests of stakeholders and maintain the integrity of corporate operation. Section 207 outlines the conduct of inspection and inquiry. Directors, officers, and employees must produce documents, provide statements, and assist with inspection. The registrar or inspector can make copies of documents and mark them for identification. They also have powers similar to a civil court, such as summoning individuals and inspecting documents at any location. These measures ensure thorough and effective investigation. Any director or officer disobeys directions issued by the registrar or inspector, they can face imprisonment up to 1 year and fines ranging from 25,000 to 1 lakh rupees. Upon conviction, they must vacate their office and are disqualified from holding office in any company. These strict penalties reinforce the seriousness of compliance during inspections and inquiry. After completing an inspection or inquiry, the registrar or inspector submits a written report to the central government. This report may recommend further investigation if necessary, with supporting reasons. The government can then decide to close the case or take further action, ensuring that every inspection leads to appropriate follow-up based on the finding. Action 200 now empowers the registrar or inspector to apply to the special court for permission to search and seize company documents if there is a risk of destruction or tampering. The special court can authorize entry, search and seizure, but companies must be allowed to make copies of seized documents. All actions must comply with the Code of Criminal Procedure, ensuring legal safeguards are maintained. Consider a scenario where creditors complain that the company is destroying accounting records. The registrar must obtain an order from the special court before entering and seizing documents. If the registrar acts without such an order, the company's objection is valid. This example illustrates the importance of following due legal process during investigation. Action 210 allows the central government to order an investigation into a company's affairs if it deems necessary. This can be triggered by a special resolution from the company, a report from the registrar or inspector, or in the public interest. The government appoints inspectors to conduct the investigation and report their findings, ensuring that serious concerns are thoroughly examined. Before appointing an inspector, the central government may require the applicant to provide security for investigation costs based on the company's turnover. This ensures that frivolous or baseless investigations are discouraged and only serious concerns are pursued. If the investigation leads to prosecution, the security is refunded to the applicant. If shareholders suspect wrongdoing and apply for an investigation, their application is only valid if a special resolution is passed by the company. For instance, if 101 out of par or shareholders apply without such a resolution, the central government is not obligated to act. This requirement ensures that only significant shareholder concerns trigger investigation. Action 211 establishes the Serious Fraud Investigation Office, SFIO, a specialized agency under the central government to investigate serious corporate fraud. The SFIO is headed by a director and staffed with experts in fields like banking, law, forensic accounting, and cyber forensics. This multidisciplinary approach ensures that complex fraud cases are investigated thoroughly and efficiently. SFIO is led by a director appointed by the central government who must have significant experience in corporate affairs. The office also includes experts in management, accounting, law, and technology. The central government can appoint additional officers and employees as needed, ensuring the SFIO has the resources and expertise to handle major investigations. Action 212 empowers the central government to assign investigations to the SFIO based on reports from the registrar, special resolution, public interest, or requests from government department. Once assigned, the SFIO takes over the investigation, and no other agency can proceed with the same case. This centralizes complex fraud investigation and ensures coordinated action. Upon receiving an order, the SFIO director designates inspectors to conduct the investigation. The SFIO follows procedures outlined in Chapter XIV, and the company must provide all necessary information and assistance. The SFIO submits interim and final reports to the central government, which may direct prosecution based on the finding. This structured process ensures thorough and accountable investigation. Once a case is assigned to the SFIO, no other investigating agency, whether central or state, can continue or initiate an investigation into the same matter under the Companies Act. If another agency has already started, it must transfer all relevant documents to the SFIO. This exclusivity prevents duplication and ensures that complex fraud cases are handled by the most qualified authority. SFIO officers, if authorized, can arrest individuals suspected of serious fraud. Offences under Section 447 are cognizable and non-bailable, meaning the accused cannot be released without court approval and a hearing for the public prosecutor. Exceptions exist for minors, women, and those who are sick or infirm. These powers underline the seriousness with which corporate fraud is treated. SFIO submits interim and final investigation reports to the central government. If the report indicates fraud, the government may direct the SFIO to initiate prosecution against the company, its officer, or others involved. The government can also seek disgorgement of assets obtained through fraud, holding wrongdoers personally liable without limitation. This ensures that those responsible are held accountable and that ill-gotten gains are recovered. Action 213 empowers the National Company Law Tribunal (NCLT) to order investigations in specific cases, such as suspected fraud, oppression, or lack of information to members. Applications can be made by a significant number of shareholders or by the tribunal itself. If the tribunal orders an investigation, the central government appoints inspectors to carry it out, ensuring that serious concerns are addressed impartially. An investigation is ordered by the central government or tribunal. The applicant may be required to provide security for costs up to 0.00 rupee. This discourages frivolous application and ensures that only genuine concerns are pursued. If the investigation leads to prosecution, the security is refunded, balancing access to justice with responsible use of resources. Section 215 prohibits the appointment of firms, bodies corporate, or associations as inspectors. Only individuals can be appointed, ensuring accountability and personal responsibility during investigation. This provision helps maintain the integrity and effectiveness of the inspection process. Section 216 allows the central government to investigate the ownership of a company to determine who has financial interest or real control. Inspectors can be appointed to uncover beneficial owners and those influencing company policy. The scope of investigation can be defined to focus on specific shares or periods, ensuring targeted and effective inquiry. Inspectors have broad powers to require officers, employees, and agents, including former ones, to produce documents and assist with investigation. They can also require other companies to provide information if relevant. Inspectors must return documents within 180 days unless further retention is needed. These powers ensure inspectors can access all necessary information for a thorough investigation. Inspectors can examine individuals on oath regarding company affairs. With prior approval from the central government or SPOM director, they can require personal appearances and record statements. These statements are documented, read, and signed, and may be used as evidence. This formal process ensures that testimonies are reliable and can be used in legal proceedings if necessary. Inspectors have powers similar to those of a civil court, including discovery and production of documents, summoning individuals, and inspecting records at any location. These powers enable inspectors to conduct comprehensive investigation, ensuring that all relevant evidence is gathered and examined. Failure to cooperate with inspectors, such as refusing to produce documents, provide information, appear for examination, or sign statements, can result in imprisonment up to 6 months and fine. Additional daily fines apply for continued non-compliance. These penalties reinforce the importance of full cooperation during investigation. Inspectors can request assistance from central or state government officers, police, or statutory authority with prior approval. This provision ensures that inspectors have the necessary support to conduct effective inspection, especially in complex or large-scale investigation. Central government can enter into agreements with foreign states for reciprocal assistance in inspection and investigation. Courts can issue letters of request for evidence abroad, and foreign authorities can request assistance in India. This international cooperation ensures that cross-border corporate misconduct can be effectively investigated and prosecuted. Section 218 protects employees who disclose information during investigations from dismissal, suspension, or adverse changes in employment terms without tribunal approval. If the tribunal does not object within 30 days, the company may proceed. Employees can appeal objections to the appellate tribunal. This protection encourages whistleblowing and ensures fair treatment during investigation. Inspectors can investigate related companies, such as subsidiary, holding company, or companies managed by the same director, if relevant to the main investigation. Prior approval from the central government is required. This ensures that all entities connected to potential misconduct are scrutinized, providing a complete picture of corporate affairs. During an investigation, inspectors can seize books and papers if there is a risk of destruction or tampering. Companies must be allowed to make copies at their own cost. Seized documents are returned after the investigation, unless further retention is needed. This power prevents evidence from being lost or altered. Tribunal can freeze a company's assets, funds, or property if there is a risk of prejudicial removal or disposal during an inquiry or investigation. This order can last up to 3 years and may include conditions or restrictions. Violations result in heavy fines and possible imprisonment for officers in default, safeguarding company and stakeholder interests. Tribunal can impose restrictions on the transfer or issuance of company security during investigation, especially if facts about the securities are unclear. These restrictions can last up to 3 years. Violations attract significant penalty, ensuring that securities are not misused during sensitive periods. Inspectors submit interim and final reports to the central government. These reports are written or printed and can be obtained by affected party through application. Authenticated reports are admissible as evidence in legal proceedings, ensuring that findings from investigation have legal weight and can be used to support further action. Based on the inspector's report, the central government can prosecute individuals, initiate winding up, or seek recovery of assets obtained through fraud. The government is indemnified for costs incurred, and if fraud is found, it can seek disgorgement of assets and personal liability for wrongdoers. These actions ensure that misconduct is addressed and stakeholders are protected. Investigation expenses are initially borne by the central government but must be reimbursed by convicted persons company, or applicants if required. The amount is a first charge on any recovered sums or property. This ensures that the cost of investigation does not burden the public and that wrongdoers bear the financial consequences. Act also covers voluntary winding up, non-disclosure by legal advisors and bankers, and applies investigation provisions to foreign company. Penalties for furnishing false statements or destroying documents include punishment for fraud under Section 447. These comprehensive measures ensure that all aspects of inspection, inquiry, and investigation are addressed, promoting transparency and accountability in corporate governance.